of a legal proceeding that's been brought by the Conservation Council and traditional owners against the Yeelirrie uranium mine approval. Now, going back, it was the Conservation Council and communities that fought for the environmental protection laws that we have in this state. They fought hard for the Environmental Protection Act to protect the environment and to reduce pollution and to prevent pollution. Those laws were never intended to allow extinction of species, but that's exactly how they've been used in the approval of this uranium mine project. This was one of the worst decisions made under the Barnett government. It was made at the time when bulldozers were in the Belair wetlands, destroying cultural heritage there, and it was made against the advice of the Environmental Protection Authority and against the independent appeals recommendation on this project. This Yeelirrie uranium project would involve a 9-kilometre long open strip mine. It would involve nearly 2,500 hectares of clearing of native vegetation, and it would involve and create 36 million tonnes of radioactive mine waste, which would remain an environmental problem for thousands of years. We also know, and the EPA recommended against this mine, because it will cause the extinction of up to 11 species of subterranean fauna. Now, the Minister approved this mine after that recommendation by the EPA and against that recommendation by the EPA, and that is what's up for trial today in the court. The environmental protection laws were never meant to allow and sanction the extinction of species, and this is a really important principle for environmental law in Western Australia that the Conservation Council and traditional owners are standing together to defend. We should not allow the extinction of species anywhere under the Environmental Protection Act. Doing so sets an incredibly dangerous precedent for any wildlife across the state, and that's why we're challenging this environmental approval in the Supreme Court today.
Doesn't the Stygo fauna exist anywhere?
The particular species of Stygo fauna that will be made extinct by this uranium mine doesn't exist anywhere else, hasn't been found anywhere else, and the proponent hasn't provided information to satisfy the EPA or the federal environmental agency that this Stygo fauna exists anywhere else. So the information that the Minister had at the time was that this mine would cause the extinction of species, and yet he went ahead and approved the mine in one of the worst environmental decisions under the Barnett government. That's why it's so important that we challenge it today.
The Labor government is saying that this is a kind of final approval. Bill Johnston suggests this, but how many other approvals are required for this?
Well, this is one of 4 uranium mines that the Labor government have said can proceed through the approval system, but there's still major hurdles ahead of all of these mining projects. This one is subject to a legal challenge, but also has a range of other approvals that need to be sought. And that is actually one of the grounds of the legal challenge today. The approval that was given by the Environment Minister didn't examine a whole range of really serious environmental issues. Simply said that they would be the subject of further assessment processes. We don't think that's acceptable, and we think that there were errors at law that were made in the making of that decision, and that will be put to the court today.
So essentially the Environment Minister shouldn't have ignored the EPA's recommendation?
The Environment Minister, we believe, made a series of errors at law, and those will be put to the court today to test the strength of our Environmental Protection Act. One of those errors was that he went against the advice of the Environmental Protection Authority, but also against his own appeal determination, which upheld that initial advice and said the mine shouldn't be allowed to proceed.
That was a mechanical appeal. Failed.
The proponent appealed the EPA's original determination, which was that the mine shouldn't be allowed to proceed, and the Minister initially upheld that EPA advice and said the EPA advice was correct and the mine is environmentally unacceptable. He then went on to make a decision to allow the mine, which went against that appeals determination. So that's one of the legal grounds that will be heard in court today. Vicky Abdullah is a dual traditional owner and native title holder for the Yeelirrie area, and it's really important that as the Conservation Council was standing together with the traditional owners of this area, the cultural heritage of this area is really significant. So Vicky, do you want to talk a little bit about the cultural connection to the land?
Yeelirrie is very important to my family. We fought over 40 years to protect our country, and once they're clear, I grew up around Uluru, Elvin Downs, Yakabinli area, but Uluru is a big, strong place that I will cover and, to not let uranium. We don't want it. We leave it in the ground. Because we've got a lot of grandchildren. Keep it so we can learn our children, our next generation to carry on our traditional land. Being on there, if it's gonna get taken away from us, it will kill us. Where we gonna go? I mean, I like being at their camp and walking and go out hunting we used to do, but we got a big fight on our hands. But we will stop it. So here today with my two aunties, they're somewhere around the corner, but for this hearing, I can acknowledge this land is so precious to us. So stop Uluru uranium going ahead. Thank you. Sorry.
Vicky, can I ask you a question? When you walk country, what do you see when you walk across Uluru?
Uluru, when I go there, we walk across there, just being at peace, like everything's going out of us, and you can feel our ancestors and getting their guidance from them, and there's one thing, I've been doing this walk for 7 years now, and it's good to take our children's out to learn our culture, our heritage, and our knowledge, what we learn them.
If you could speak to the judge today, what would you want to say to them from your heart?
From my heart, just keep it in the ground.
Is there anything we haven't asked you that you'd like to say?
Not at the moment.
Thanks. Can I ask you a question here? If you finish. Here's the EPA decision was pretty narrow in terms of what it was saving. Do you think they ignored issues around waste on site, or do you feel that they covered, apart from the fauna, everything was pretty good in the EPA report?
Well, there was a range of environmental impacts with this mine that weren't actually properly examined as part of the original environmental impact assessment process by the EPA. And one of the arguments that will be made in the court today is that the conditions that were put on this project, which simply allow the proponent to then go and do further studies and require further approvals, create a whole lot of uncertainty. It's uncertain what the environmental impact is actually allowed with this project because of the way that this decision was made. So no, we don't believe that proper and adequate attention was given to a whole range of environmental issues, and we believe that conditions on this project reflect that, and that's one of the things that will be argued today in the court.
Are you finding it easy to run court cases given the cutbacks there have been on groups like Environmental Defenders Office?
Well, one of the problems we have in Western Australia is that we don't have a merits-based court system where we can actually talk about the environmental merits of these projects. We have to actually go through legal arguments and construct an argument that the Minister made legal errors in the process of decision-making because we don't have an environmental merits court here. In this case, we believe that there are and there were serious legal errors in the Minister's decision-making process. We believe it reflects a rushed approach by the Barnett government to get these environmental approvals done before the election, and indeed this decision was made just weeks before the election while the bulldozers were in the Belair wetlands. So we believe this decision was rushed, and in the process legal errors were made, and that's one of the arguments that will be made to the court.
I can ask you one more question, which is what's it like to be off-country here down in Perth, coming to court? How are you feeling?
Every time I come down to Perth, it's like in the past laying around, just kind of zoom around, but back home on country, you can just take it easy and relax. Thank you.
Thanks so much.
Can we get a quick photo of both of us?
Well, it'd be good if we could get the other two dual native title holders, Shirley and Lizzie. Yes.
So Shirley and Elizabeth Wanyabong, native title holders, for the dual native title group.